Welcome to Law Sessions. I am Jennifer Housen. In this session, we will review the topic of co-ownership, and in particular, we will focus on severance. In another lecture, of course, we will review co-ownership as it relates to trusts of land, but in the next hour or so, our primary focus will be on co-ownership and how it operates in the context of severing the joint tenancy into a tenancy in common. But first, we want to start with the basic definition and what exactly we mean when we speak of co-ownership. Now, co-ownership is a situation where, in land law, two or more people hold an interest concurrently in the same piece of land. Now, you can have a situation where there is express co-ownership. So the land is sold or transferred, conveyed, that is. Remember what I said about conveyed? When an examiner says that, it is usually by deed. So you can have a situation where, under express co-ownership, the land is conveyed to two or more persons by an express act. So it is actually drafted in terms of the two persons, namely the legal owners, being placed on the deed. Equally, let's assume that the sale, for example, is by an agreement, which might then take it into the realms of being an equitable transfer. Again, if it is that expressly on the transfer, it states the name of the two legal owners, then what you have is, of course, a joint tenancy and co-ownership. Well, there are two main types of co-ownership. There's the joint tenancy and there's the tenancy in common. Now, the joint tenancy and the tenancy in common defines the two ways that people may own land concurrently. Now, when we talk about joint tenancy and tenancy in common, it speaks to the way persons can own land or hold an interest in land. What it doesn't say is that this is legal or this is equitable, because joint tenancy can operate both at law and in equity, as we'll discuss later on. But the first thing to consider is the way that two or more people can own land or own an interest in land, and that is that they hold it as joint tenants or they hold it as tenancy in common. Now let's consider first of all what is meant by joint tenancy. Well, the thing with land law sometimes is that the words used do not necessarily reflect what it is. So when we think of tenancy, immediately it conjures up somebody being a renter. That is not what it means. Tenancy looks at the way the property is held, and tenancy can be joint or tenancy can be in common. So the word tenancy simply means here how it is held. So in a joint tenancy, the co-owners, each party called a tenant, holds jointly. It means that they hold as one unity. It means they hold as one person. And it's interesting because in English common law, as it talks about joint tenancy, you have that there was a period in time where you even had what was called tenancy by the entirety, which nowadays, for example, in New York jurisdiction, they still have something like that, which operates as between husband and wives, which is that there's a tenancy by the entirety. But for English land law, what we're looking at here is that you have two persons holding as one unity. So what happens in a joint tenancy is that you do not have a separate individual share in the land. Rather, each person owns the whole, as it were. Now, the main feature of the joint tenancy is that what is called the four unities must be present. Now the four unities, I will go into further, but in order to create a joint tenancy, the co-owners must, of course, ensure that this principle of the four unities is present. An easy acronym, of course, to remember the four unities is PITT, P-I-T-T, and that is possession, interest, time, and title. Because those are the four interests. There must be the interests among the co-owners as to possession. They must jointly hold in respect of the same interest. They must have gotten it at the same time, and they must have got their interest in the same title. Now let's look at these then. As it relates to the unity of time, the co-owners must have acquired the property at the same time. Now you will see later on when we discuss, for example, tenancy in common, that the idea is that a tenant in common can actually acquire an interest in land at a later time than other persons within the same ownership of the property. But because he's acquired at a different time, he simply cannot be a co-owner who is joint. So for joint tenancy, time says they must have acquired it at the same time. They must have acquired it in the same title to the property. So if a condition applies to one owner and not to another, there is no unity of title. They must have gotten it in respect of the same interest. So the co-owners must have the same interest in the property. So for example, one co-owner cannot have a life estate and another co-owner have a fee simple absolute in possession. The co-owners must have an equal right to possess, and that is the last requirement. Possession must have been that they have an equal right to possess. If any of these elements is missing, the joint tenancy is ineffective, and the joint tenancy will be treated as a tenancy in common in equal shares, dependent on how you take the discussion forward. What then is the effect of joint tenancy? Well, the point of the joint tenancy is that everyone takes as a whole. So nobody has an individual share. The joint tenancy rests on what is called the right of survivorship, or jus accrescendi. And jus accrescendi says that if any one of the joint tenant dies, his interest will automatically survive, meaning that it will vest in or pass to the other joint tenants. Now, this is of course the common law. And so the problem with the joint tenancy is that if you and I own Blackacre as joint tenants, you do not have an interest separate from mine. You hold and own the whole in the same way that I hold and own the whole. The point being that if you pass away, then your right or any interest that you have will survive to me, but you do not have a freestanding right. And equally, if I pass away, of course, whatever rights I may have survive to you. The problem, of course, is that in a joint tenancy situation, you get a kind of lottery effect, which means that you're looking at the last man standing. So it is really a survival of the fittest type scenario. Because if 4 persons own as joint tenants, then if you are looking at those 4 persons as A, B, C, and D, when A dies, it now survives to B, C, and D. If B dies, it survives to C and D. And if C dies, then D, as the last man standing, of course, gets the entire property free and clear to himself. So the idea then is the parties do not have an individual interest, as I said. They hold the whole together. And as one tenant dies, cannot leave his interest in the property to his family in a will or otherwise, because he doesn't have anything to leave. Because the property and the way the property is held is such that it is indivisible, and it is certainly not separate so as to give any party a share at all. When we come back, after this brief break, I will then focus on the tenancy in common.